it's Leila from My RA Lawyer, and I'm here to talk to you today about the 3 things you absolutely need to know when it comes to proxy voting for your clients. So no, you can't just go with the fund's recommendation on what to vote for. And no, you can't close your eyes and randomly pick which one to pick. No, that doesn't work that way. And no, you cannot leave these proxy voting documents on some admin's desk gathering dust. It does not work that way. Why? Because believe it or not, your fiduciary obligations also extend to you proxy voting for your clients. And so these are the 3 things you absolutely need to know when it comes to proxy voting. So when you as the financial advisor are proxy voting for your clients, you are held to the fiduciary standard. That means you must do what's in the best interest of your clients. So specifically, you want to make sure you're getting the guidelines related to the proxy voting. You want to conduct due diligence on the underlying issues, the recommendations from the fund, and the options. You want to review the client's profile and determine what's in their best interest when it comes to this vote. You want to disclose any potential conflicts of interest you may have to your client. You want to make sure you keep a record of the voting option you made. And that doesn't mean your job stops there. No. You have to monitor the vote and deliver any updates to your clients about how the vote went and what that means to your client. You also want to make sure you're monitoring the fund to ensure they're following through with their obligations. And finally, you want to routinely review your policies and procedures around proxy voting to ensure that these processes are followed uniformly amongst all of your advisors. And this is how you complete tip number 1, complete and follow through with your fiduciary obligation. So let's talk about the second thing you need to know when it comes to proxy voting. There are actually circumstances under which you absolutely cannot proxy vote for your client. So when are you not allowed to vote for your client? Well, first, if they tell you not to. Your client can absolutely come to you and say, hey, I do not want you voting proxies for me. In that case, you want to make sure the client file is updated accordingly with a note or written communication from the client stating they don't want you to vote proxies for them. The second occasion where you may not be able to vote proxies is if the vote prohibits financial advisors from voting on behalf of their clients. So the underlying fund can tell you, sorry, financial advisor, your clients have to vote directly. The third occasion which you may not be able to vote proxies is if you have such material conflicts of interest that prohibit you from making such a vote, meaning you are not able to act in your fiduciary capacity and put the client's interest ahead of your own. And finally, the fourth occasion which you absolutely cannot vote proxies is if operationally it's not feasible for you to do so. So this means don't try to half-ass it. Don't try to kind of do it. If you're not able to do it operationally or guidelines prohibit you from doing so, then you absolutely cannot proxy vote for your clients. And the third thing you absolutely should know is that there can be some very serious repercussions if you don't do a proxy vote that's in the best interest of your client. You can face 3 different types of loss: reputational loss, financial loss, and potentially losses due to regulatory actions. That's right. If you fail to be a fiduciary to your client during the proxy voting process, the SEC or State Securities Commission you are subject to can fine you, suspend you, or bar you from the industry. These things are disclosable events. They go on your Form U4. They're publicly available on BrokerCheck and IAPD, which means you could also have harm to your reputation. And let's be real, you don't want reputational harm. You don't want to lose current clients. You don't want future clients to not use you because of these disclosures. And finally, you can face financial loss. Poor proxy voting could mean that the repercussions to your client means they've lost out on certain opportunities or they're not making the kind of returns they could have if the vote had gone a different direction, which again could lead to fines from the SEC, them deciding to leave your business and not refer their friends and family to you, or prevent you from bringing on new clients. So, regulatory harm, reputational harm, financial harm. These are the repercussions of not doing proxy voting in accordance with what's in the client's best interest. So, if you have questions about your proxy voting process, whether it's enough to meet your fiduciary obligations to your client, then don't wait. I can tell you right now, this is something the SEC is looking at. It is something the state securities commissions are looking at. So don't waste time. Don't put yourself and your clients in harm's way. Give us a call today. Our compliance and legal professionals are ready to help you right now. 770-462-2118. I'll talk to you soon.